Today, we are meeting with Eric Dreiband, the Assistant Attorney General for the Civil Rights Division and the Department of Justice. In addition to his work in the private sector, Mr. Dreiband has served in several positions over the years throughout our federal government, including as the General Counsel on the Equal Employment Opportunity Commission from 2003 to 2005, and as Deputy Administrator of the Department of Labor's Wage and Hour Division, and we welcome you, sir. For more than 60 years, the Civil Rights Division at the Department of Justice has been a shining example to our nation. It has fought for marginalized communities, protected basic rights, and ensured justice for all communities. In communities of color, the Civil Rights Division holds a place of reverence that is well earned through a record of achievement. The mission of the division is essential to ensuring that all Americans receive equal protection under the law. Sadly, that proud record of service is in peril under this administration. The attacks on long-standing precedents and effective policies have been unending, from preventing the use of consent decrees and addressing systemic issues with local law enforcement, to a lack of enforcement of the Voting Rights Act, to rescinding guidance protecting transgender students. The department has pulled back on policies that have protected millions. The department has also chosen to change sides on cases involving cornerstone civil rights issues like affirmative action and discriminatory voting laws. Earlier this year, the Washington Post reported that the Justice Department has been tasked with analyzing current disparate impact guidance and policies, any revision of which could severely undermine our fair housing laws. The pace of these changes is dizzying and disturbing. Many of them undermine the core mission of the Civil Rights Division. Last month, in what can only be described as a Freudian slip, the President praised the, quote, abolition of civil rights, end of quote. Unfortunately, that statement hits far too close to the truth. This subcommittee intends to look at the work of the Civil Rights Division very carefully, and we expect that the dollars we appropriate to the department will be used in a manner that protects the vulnerable communities the division has stood up on behalf of for many decades. Once again, we welcome you, Assistant Attorney General Dreiband, and we look forward to your testimony. Before I proceed, let me just say that my comment before really was sincerely spoken. Growing up politically and growing up physically, but certainly politically, the Justice Department was that place that you looked to for fairness and for coming in, basically, and straightening things out when they were being unfair. That's why a lot of us are sad at what we think is happening in the Justice Department, especially in this division. Ever since the Supreme Court's Shelby County versus Holder ruling ended some federal oversight under the Voting Rights Act, there has been a historic increase in the threat and reality of voter suppression. The House last week passed H.R. 1 to reform voting rights protection and upgrade election security, among other things. Question: how many cases is the division, either the voting section or the criminal section, working in Georgia and in Florida?
Well, Chairman Serrano, as you know, the right to vote is one of the most important rights we have. It is secured by both the Constitution of the United States and several laws, including the Voting Rights Act. As I mentioned in my opening statement, we have participated in various ways through litigation and otherwise in 6 Section 2 Voting Rights Act cases since 2017. With respect to ongoing investigations, voting or other matters, I cannot comment on those, but I can assure you that the message that I've delivered to the voting section of the Civil Rights Division, as well as the criminal section of the Civil Rights Division, is that we are committed to aggressive and zealous enforcement of all of the laws within our jurisdiction, including the Voting Rights Act in particular. That law, as you know, was enacted in 1965, and it was primarily designed to combat race discrimination in voting. But it does reach other areas as well, and ensures protections for people who struggle with English language, for example, and other protections as well.
So with that in mind, how does the Civil Rights Division prioritize efforts and manage its election-related workload?
Well, we do that in many different ways. So we, for example, have settled cases to ensure the integrity of state voter laws. We also, in the 2016 and 2018 elections, dispersed several people throughout the United States to monitor the polls. In fact, in the 2018 election, I spent much of the day with a command center run by our criminal section and with our voting section attorneys who were monitoring in real time as voting was actually happening. Complaints, concerns that people were raising. We worked in coordination with the Federal Bureau of Investigation to both monitor the activities on that day and in addition disperse people throughout the United States to several jurisdictions to monitor the voting and report on any problems that anyone saw. We also conduct investigations in the various states around the country to ensure that they are complying with the federal voting laws. And then, of course, we engage in litigation through the federal court system, of course, various federal laws within our jurisdiction. Obviously, we prefer to settle cases if we can, and oftentimes we're encouraged that states will work with us to reach an appropriate resolution to a dispute, but if we have to, we're prepared to litigate and do litigate cases in the federal courts throughout the United States.
Now, I know you can't get into specific cases, but do we know what the top number of complaints are in voting-related issues?
Chairman Serrano, I don't know that data off the top of my head, but we do take complaints from the public, and our voting section investigates complaints. Our criminal section does as well, and we work with the Federal Bureau of Investigation, and at times other components of the federal government as well. For example, the Department of Homeland Security. And other aspects of the executive branch of the government to investigate complaints, either alleged violations of the Voting Rights Act, the National Voter Registration Act, the Help America Vote Act, and other laws as well.
Could you at a later date give the committee some numbers just for our information of what's the number one complaint, you know?
Chairman Serrano, I will certainly take that back to the department and working with our Office of Legislative Affairs, provide you with whatever data we can to satisfy concerns you may have, as well as other members of the subcommittee.
Thank you. H.R. 1 is passed by the House would add significant new election system protections. If enacted, how would voting section workload be affected? What resources would help you carry out your mission, as you understand H.R. 1?
Chairman Serrano, I'm not familiar with H.R. 1 and would look forward to reviewing the bill and in consultation with the many dedicated and career attorneys in our voting section, talk with them. Our policy section of the Civil Rights Division would also look at it. And then I'd be happy to take it back and work with you and your colleagues on it, as well as in conjunction with what we have at the Justice Department. It's called our Office of Legislative Affairs. That office provides a liaison, as you know, between this subcommittee and other committees of the House of Representatives, and it's something that we would look at and weigh in as appropriate.
Mr. Dreiband, how much staffing and funding does the division devote to police reform?
Well, I would say two of our sections primarily deal with police departments in this through the Civil Rights Division, our special litigation section and our criminal section. But of course, other sections of the Justice Department and the Civil Rights Division also do it as well. For example, police departments are governed by Title VII of the Civil Rights Act of 1964, in that they are prohibited from discrimination because of race, sex, and other protected traits. And our employment litigation section enforces that law. So it does vary by statute. Each of those sections, the three sections that I mentioned, have several dozen attorneys and investigators and other professionals who work with them.
Now, From your knowledge, is that particular dedicated funds amount lower than it's been in past years? Has it held steady over a period of time?
Well, I think that the numbers vary. They vary from section to section in terms of increases or decreases in staffing. Some sections have more attrition than others. So, for example, our criminal section has seen increase in staffing in the last couple of years, but it does vary by section.
And how many reform agreements are now in place? And how many are under consideration, either in negotiation or in implementation?
Chairman Serrano, I'm sorry, what kind of agreements were you asking about? I didn't quite hear that.
Reform agreements.
Well, Chairman Serrano, we enter into different kind of agreements with police departments. They could be in the form of a settlement agreement of a disputed matter. They could be in the form of a consent decree, as I was talking earlier. So it does vary in terms of the form of the agreement. We don't use the term reform agreement when we settle a matter with a police department or any other organization or institution. So it does vary in terms of the type of resolution that we have with these organizations. But so I'm not sure how to respond more precisely than that.
You mentioned consent decrees, and we have an understanding that there have been less of those agreed to. Is that correct?
I don't, Chairman Serrano, I don't know the numbers of the consent decrees that this Civil Rights Division has entered into. We have entered into many, many consent decrees through the various sections of the Civil Rights Division over the last few years, many of which predate my arrival, obviously. But so I don't know the numbers off the top of my head. I think it would vary from section to section of the Civil Rights Division.
Okay, well, you can provide that on the record, and we'll also provide you with more information to clarify our questioning.
Thank you, Chairman Serrano.
On November 7th, former Attorney General Sessions issued a policy memo to curtail the use of judicial consent decrees, saying it is not the responsibility of the federal government to manage non-federal law enforcement agencies. Has the policy been implemented, and did it lead to terminating agreements or setting deadlines?
Chairman Serrano, you're correct that on November 7th of 2018, then Attorney General Jeff Sessions did sign a memorandum about consent decrees with respect to state and local government institutions. That memorandum established certain kinds of procedures, both with respect to obtaining approval of consent decrees and standards that govern consent decrees. The memorandum has not resulted in any kind of artificial termination of any consent decree within the jurisdiction of the Civil Rights Division since it issued, nor have I given any direction to anyone in the Civil Rights Division to terminate any existing consent decree artificially or otherwise as a result of that memorandum. So consent decrees that existed before that memorandum and that have not otherwise expired remain in place, and our various sections of the Civil Rights Division continue to enforce them. You know, we do consult as a result of the memorandum with the Office of the Associate Attorney General, for example, or the Deputy Attorney General as appropriate. And we're continuing, though, marching on and soldiering on with respect to our law enforcement activities.
Then you wouldn't know how many agreements were affected and where they were affected.
Chairman, sorry, I didn't hear the last part of your question.
And you wouldn't know how many of these agreements were affected and where at this point.
Yeah, Chairman Serrano, in terms of the existing agreements, I don't believe any of them were affected at all. We don't read that memorandum to be retroactive or anything like that to affect pending consent decrees. Rather, it was a directive, at least as I read it, on a going forward basis about how the Civil Rights Division, but not just the Civil Rights Division, but the Justice Department generally, will seek to obtain consent decrees with respect to state and local government organizations and institutions, respecting, of course, the federalism concerns that are at issue in those cases, because we have state and local government organizations and the federal government bringing enforcement actions in those cases.
In your confirmation hearing, you testified that, and I'm quoting, the Division's Special Litigation Section is entrusted with the role of enforcing federal laws, protecting the civil rights of individuals in our communities who interact with state or local law enforcement officers, end of quote. You also said that while intervention may not be appropriate in every case, the division must stand ready and willing to assist state and local authorities when necessary. With that in mind, what standards should DOJ use to identify organizations in need of review or reform?
Yeah, we, through our special litigation section, we enforce a variety of statutes, and we gain information about alleged violations of those statutes in different ways, through the local communities, through advocacy groups, through individuals. Our special litigation section then conducts investigations as appropriate. Again, each law varies in terms of the exact process available to us. For example, some statutes provide subpoena power during investigations in civil matters and others do not. For example, the Civil Rights of Institutionalized Persons Act, which is one of the laws that the Special Litigation Section is entrusted with enforcing. That does, thanks to amendments by you and your colleagues in the Congress, does authorize us to issue subpoenas, for example, to compel production of information. Under that law, for example, we recently issued findings letters against both a jail in Kentucky and a prison in Virginia, where we found that there was a pattern of practice of violations of the Constitution by law enforcement officials in those cases, and those occurred after lengthy and thorough investigations by the very dedicated staff and attorneys in the Special Litigation Section of the Civil Rights Division. And we're now working with those institutions, hopefully to bring about a resolution to those alleged violations, and to make sure that in those cases the institutions are complying fully with the Constitution of the United States and the federal civil rights laws that are within our jurisdiction.
Thank you. I can't let it pass, my good friend, and I mean my good friend, Mr. Palazzo. No Democrat supported undocumented folks from voting in elections. It is a good approach that is used every time we bring up voter suppression or the difficulty of that is made in some states for you to vote, that the other side brings up voting by undocumented. I don't know what it feels like to be an undocumented person. I was born a citizen in a territory, but everything I know about these folks is that they would rather stay in the shadows. The last thing they want to do is get caught voting in an election that they're not supposed to be voting in, because that would be the end of their stay here, or worse, they would stay here under another circumstance behind bars. So I don't think that that's something for us to worry about. Let me ask you one last question, and then we'll wrap it up and let you go enforce the laws, you know. FY19 proposed to put community relations services in your division. Is this a good idea in your opinion?
Well, the Community Relations Service historically has been separate from the Civil Rights Division. I understand there is a proposal to make it part of the Civil Rights Division. The Community Relations Service historically has served a different function than we do in the Civil Rights Division, in that the Community Relations Service has historically helped work with communities in an amicable way to calm tensions, to build trust, oftentimes when there are various controversies in a particular community. In the Civil Rights Division, as I've said earlier, and you referenced Chairman Serrano, we are primarily charged with enforcing the laws within our jurisdiction through either criminal prosecution or civil lawsuits or investigations, things of that sort. So with respect to the proposal, I really think that's something that you and your colleagues here in the House of Representatives and your peers over in the United States Senate should decide. Whatever you decide and whatever you do, we'll do our duty as best we can. And if you decide and your colleagues decide to combine the Community Relations Service with the Civil Rights Division, we'll do our best to make sure that that both the Community Relations Service and the Civil Rights Division continue to function as best and efficiently as they can, given the limited resources that you and your colleagues appropriate to us.
Thank you. Mr. Adderhold, do you have any closing comments? Let me just thank you for being here with us today. And I'll end the way I started. You know, I come from a generation of people who saw the Justice Department as the one place you went to for relief. And every time the Justice Department got involved, it was not to hurt someone unless somebody was doing something wrong. It was to defend the rights of people, and even those who were in the margins of society in many ways, financially and otherwise, felt protected. And as I said before, for the African American community, it became that one place, especially, where the justice could be brought about. And so I would hope that that's still the feeling. I would hope that that's what you consider to instill in the people who work in this section. And I would hope that we can continue to have a Justice Department that we can remedy what's wrong, grow on what's right, and serve the people well. And I thank you.
Thank you, Chairman Serrano.
And this hearing is adjourned.
Thank you.